Good morning, everyone. We're going to begin in just a moment as we wait for a few more people to transition over into the live portion of the program. Welcome, everyone, to our hospitality law seminar on legal challenges in the contract food service management industry. This is presented by HospitalityLawyer.com. Today's date is November 15th, 2023. Take a look at our upcoming 2024 virtual seminar series. If you want to make a note of these dates, we'll focus on quick service and fast casual aspects in the restaurant industry, Wednesday, February 21st. Then we'll do in the second quarter, labor and employment challenges in the hotel and restaurant industries, Wednesday, May 22nd. Risk management and loss prevention in those industries, Wednesday, August 21st. And then, of course, we typically wind up the fourth quarter with our legal challenges in the contract food service management industry, which is scheduled for Wednesday, November 13th, all in 2024, all kicking off at 10 a.m. Central Time. And of course, all of these are recorded and available on demand in our library. Let's also remind you of our face-to-face hospitality law conferences for 2024. We are just about ready to pin down the dates for our Houston event. It will most likely be the next to last week in April. And then, of course, our Hospitality Law Conference, DC, that will happen at the Army Navy Country Club in Arlington, Virginia. Once again, that is a one-day program. We typically host the first 2 weeks of October, and the program in Houston is a day and a half. Let's get started with today's program. Kicking us off around sponsorships and third-party relationships in the alcohol space is Miss Lauren Voke with Gray Robinson. Lauren works out of the Miami office for Gray Robinson. Her practice focuses on the rules, regulations, trends, and business practices governing the marketing, sale, and consumption of alcohol beverages. And as most of you know, Gray Robinson has a national practice in the alcohol space, including licensing, regulatory aspects, but also around mergers and acquisitions and facilitating the transfer of licenses in that space. Lauren specializes in counseling alcohol industry members and unlicensed third-party providers on all the promotional activities, including sampling, the use of promoters or influencers, which is big today, sponsorships, advertising, and social media. And as everybody on this seminar knows, that can be a very sticky wicket with the three-tier situation that we have in alcohol beverages. Ladies and gentlemen, please welcome Lauren Voke.
Thank you, Stephen, so much. Like you said, my name is Lauren Voke, and I'm going to be talking to you today about alcohol sponsorships and the considerations that everybody here needs to keep in mind when these sponsorships come into play. In the age of increasing concessionaires, food halls, and multi-party arena management, it is not uncommon to see multiple businesses operating out of the same building or even the same space. Specifically, when either you or your clients are hired to operate as a concessionaire or otherwise provide food management services, clients are often unaware of the intricacies of the law that apply to the privileges of selling alcohol. As a result, you or your client may enter into a relationship with a third party that puts you or your client's ability to sell alcohol at risk. Within the past year, we've had an uptick in requests from concessionaires or food managers where either they or their client have received the opportunity to enter into a sponsorship arrangement with the supplier and the corresponding regulatory considerations. This presentation is going to cover the key considerations relating to when you or your client can accept sponsorship dollars and assets, and what to do if you or your client accept them. I want to start off with a real world scenario. Next slide, please. I want to start off with a real world scenario. Let's say you're operating a cafe for your corporate client. You have a liquor license because your client wants you to host happy hours and other events throughout the year for its employees. Your corporate client enters into a sponsorship arrangement with a large beer manufacturer. The terms of the sponsorship arrangement require the corporation to host 3 happy hours serving only the large beer manufacturer's product. In exchange, the large beer manufacturer gives your corporate client $500 Visa gift card to purchase beer for the happy hour, in addition to some branded materials to display during the happy hour. Your client gives you the branded materials and the $500 Visa gift card to prepay for a round of drinks for the happy hour. Is this going to be allowed? Let's find out. First things first, it's important to understand why sponsorships are such a hot topic when it comes to alcohol service. Unlike most consumer products, sponsorships relating to alcoholic beverages are heavily regulated at both the federal and state levels. The industry is separated into 3 distinct tiers: the manufacture, the distribution, and the retail sale of alcoholic beverages, as Stephen mentioned, the 3-tier system. Manufacturers must sell to distributors, who then must sell to retailers like food management companies and concessionaires, who then sell to the end consumers. Federal and state laws prohibit overlapping interests between these tiers and do not allow upper tier industry members to provide anything of value to lower industry members like retailers unless an exception in the law applies. These prohibitions are called tied house laws and are aimed in large part at preventing unlawful relationships between large suppliers and retailers that prevent smaller brands competing for shelf space, marketing opportunities, and of course, sponsorships. Anything of value is broad enough to capture any item that an upper tier industry member may want to give a retailer that is not explicitly covered by an exception. Next slide, please. Both federal and state laws apply to the alcohol industry. As a general rule of thumb, whatever license you hold will come with its own laws and regulations. Federal tied house laws primarily apply to upper tier alcohol industry members who hold federal TTB basic permits. In other words, federal laws regulate manufacturer and distributor conduct, but not retailer conduct. State laws bridge this gap by not only regulating manufacturer and distributor conduct, but retailer conduct as well. All of these laws, whether federal or state, generally prohibit a manufacturer or a distributor from sponsoring a retailer or entering into any kind of sponsorship arrangement that would directly or indirectly result in a benefit to the retailer. First, I'm going to focus a little bit on federal law. The Federal Alcohol and Tobacco Tax and Trade Bureau, otherwise known as the TTB, enforces the Federal Alcohol Administration Act, which prohibits certain marketing practices that give industry members unfair advantages over other industry members. For example, the law on the screen is generally a law that sponsorship agreements violate. Any contract or agreement, whether written or unwritten, which has the effect of requiring the retailer, whether directly or indirectly, to purchase alcoholic beverages from the industry member beyond a single transaction is prohibited. Examples of such contracts are an advertising contract between an industry member and a retailer with the express or implied requirement of the purchase of the advertiser's products. There's a few parts of this law I'd like to point out. The first is the written or unwritten language. This language is broad enough to capture both a written agreement, your stand-of-the-mill contract or a PO, or any kind of handshake, wink-wink agreements that even though it's not expressly being memorialized, the impact of the agreement still exists. The direct or indirect language is broad enough to prevent upper-tier industry members from using third parties or related entities to serendipitously provide sponsorships or other items of value to a retailer. In other words, a manufacturer that provides your food manager's corporate client with sponsorship dollars that are then passed to your client would be the same violation as if the manufacturer provided the sponsorship dollars directly to your client or the food concessionaire. Third-party marketing companies and intermediaries cannot be used to circumvent alcohol laws and allow a manufacturer to give something to a retailer that would not have otherwise been allowed. In other words, just because your client receives something from an alcohol manufacturer and then gives it to you doesn't mean that you can accept it just because it came from your corporate client. The express or implied language is broad enough and intended to target the true heart of the agreement and the actions taken regardless of what has been agreed to or memorialized. Any kind of impacts that an agreement may make, whether it's excluding other products of other companies or merely requiring the food manager to purchase less products than it would have but for the agreement with the industry member, is still going to be classified within the area of a sponsorship agreement. Now we're going to talk about state laws. State laws generally mirror federal tied house laws, and then they revise the laws that regulate the manufacturer and distributor conduct to apply to retailer conduct. For example, while federal law prohibits a manufacturer or a distributor from providing of something of value to a retailer, state law could prohibit a retailer from accepting something of value from a distributor or a manufacturer. Therefore, that liability is created at the state level. Although federal law applies uniformly, it is very important to note that that is not the case with state law. As with most states, each state has different statutes governing the alcohol industry. As a result, there are at least 50 different sets of statutes to consider, and most states promulgate regulations to further regulate what the statutes say, therefore creating upwards of 100 bodies of law. While there is some degree of national uniformity, very rarely are any two bodies of law the same. Therefore, multi-state and national operations can be difficult to navigate because an action that is legal in Alabama may not be legal in Wyoming and vice versa. When evaluating the permissibility of a sponsorship, the first questions I will ask is, where is the sponsorship taking place? Will the sponsorship extend to more than one state? And what venue is the sponsorship for? So I've been talking to you a lot about what you can't do. So a common question is, well, what can I do? Recognizing that alcohol brands have legitimate interests in promoting brands to consumers, and they're not always acting in bad faith or trying to blow out their competition, federal and state law grants certain exceptions to the rules that allow alcohol brands and retailers to have lawful relationships that support and market an alcohol brand. These exceptions are very, very specific and will include marketing materials such as advertising materials, napkins, glasses, signage, and other items. Some states, like New York, specifically regulate sponsorships, whereas other states, like Florida, do not regulate sponsorships at all and will merely look to these exceptions in the law to determine what is or is not allowed when it comes to sponsorships. If an upper-tier industry member is merely providing a retailer with items that are allowed under federal and state law, then such conduct is not going to be considered a tied house violation because an exception applies. Where sponsorships get risky is when the upper-tier industry member, like a manufacturer or a distributor, asks for something in return, such as exclusivity, preferential treatment, or some other quid pro quo transaction. Sponsorships have historically, but not always, been tolerated by agencies when there is complete separation between the owner of the venue expecting the sponsorship and the truly independent concessionaire. For example, if your client is a sporting arena and then your sporting arena client accepts a sponsorship, as long as none of that sponsorship kind of comes to you as the concessionaire or the food manager, it's generally not going to be deemed an impermissible thing of value. When impermissible things of value come into play is, like I said, when the manufacturer or when you as the food concessionaire or food management company is returning or acting in a way that you would not have otherwise acted, such as you're excluding competitors' products, you're accepting some kind of money or inducement from the manufacturer, you're offering exclusivity, or there's some other quid pro quo transaction. You're giving me this and I'm giving you that. A good example is a food hall. Food halls, at least in Miami where I'm based, we've really seen an uptick in food halls. So a good example I like to give is this one. Your company runs alcohol operations at a food hall alongside 4 other unaffiliated food vendors. One of the food vendors is a taco stand. The taco stand has entered into an arrangement with a large cerveza supplier. The large cerveza supplier gives the taco stand 500 cerveza supplier branded keychains to hand out to every customer that purchases a taco every Tuesday during the month of May, a customized menu, and $1,000 for the taco stand service of handing out the keychains. This scenario, where it might seem a little risky, is going to be allowed because the arrangement has nothing to do with you or your alcohol service. Is it possible that the consumer may be more likely to purchase the large cerveza supplier's product that day because of the promotion? Of course, that's probably the point, right? However, your sales of the large cerveza supplier's product is only a byproduct of the sponsorship agreement, and it has nothing to do with you, and you did not engage in that arrangement. If you had accepted $1,000, or if the taco stand gave you the keychains to then give out, then we're getting into impermissible sponsorship territory. But just because there's a sponsorship that's going on out of a property that you operate on doesn't mean that it's going to impact your sales or impact your ability to sell alcohol. A large question I get is, well, what are the practical risks? Alcohol sponsorships have been heavily scrutinized by TTB and state regulators through various enforcement actions. When a sponsorship is being investigated, agencies will follow the money to determine where sponsorship funds originated, who had access to the funds, and how the funds are ultimately being used. TTB and state agencies often partner up to investigate tied house violations to ensure that both sides of the arrangement are being evaluated, meaning both the retail and the manufacturer and distributor side are being thoroughly investigated. Any violation of state or federal tied house laws could result in significant financial penalties, in license suspension, or even license revocation. Here are 3 recent examples of federal tied house investigations. Tito's settled on a $300,000 and $500,000 offer in compromise because it entered into sponsorship agreements with various sports and entertainment venues to which the venue retail concessionaires were induced to purchase Tito's vodka to the exclusion of other competitor products. 2 wholesalers in Chicago settled on an $850,000 offer in compromise for paying sponsorship funds to third-party concert promotions that was ultimately managed or owned by a retailer. Anheuser-Busch settled on a $5 million offer in compromise for entering into sponsorship arrangement that included providing the concessionaires with fixtures and equipment, reimbursing retailers for installing new draft systems, reimbursing credit card swipes, and using third parties to provide money and other things of value to retailers. Now, these are obviously very considerable penalties that should be factored into risk calculus when engaging in sponsorship arrangements. However, as being retailers, state law often sets forth penalty limitations or penalty guidelines that'll cap what a retailer can be fined for situations like this. However, the bread and butter of state agencies is that numerous violations could result in license suspension and license revocation, which not only immediately impacts your ability to do business in that state, but it could even prohibit future business operations by impacting other licenses held or even impacting your future ability to obtain a liquor license. Now that we're experts, let's go back to the fact pattern that I presented at the beginning of the presentation. Your client is a food management company that operates a cafe for a corporation. Your client has a liquor license because it conducts happy hours and other events throughout the year for the corporation and the corporation's employees. The corporation enters into a sponsorship arrangement with a large beer manufacturer. The terms of the sponsorship arrangement require the corporation to host 3 happy hours serving only the large beer manufacturer's product. In exchange, the large beer manufacturer gives the corporation a $500 Visa gift card to purchase beer for the happy hours, in addition to some branded materials to display during the happy hours. The corporation gives your client the branded materials and the $500 Visa gift card to prepay for a round of drinks at the happy hour. The client comes to you for advice. There are 3 things that should have rung your ears when you were reading this. The first is only the beer manufacturer's product. It is a clear-cut violation that a manufacturer distributor cannot require a retailer to only serve their kind of beer at an event. That is going to be numerous federal violations, and that is when we get into the really high violations that we saw a few slides ago. The next is the Visa gift card. There is rarely an instance where sponsorship dollars your client receives can be passed along to you, regardless of how the money is spent, because you, as the retailer, or your client, as the retailer, is still benefiting from a monetary value that the manufacturer gave to a third party. In this situation, a federal and state agency is going to follow the money. They're going to ask you where that $500 came from. They're going to go to your corporate client. Your corporate client is then going to say that the manufacturer and the agency would then have followed the money to an impermissible thing of value. The last is the branded materials. Well, this depends on the state that you're in. Most states allow alcohol brands to provide such items to retailers as part of the marketing exceptions that we discussed earlier in the presentation. Such items are heavily regulated and scrutinized, so it's always recommended to check with state law to confirm whether the specific item is in fact considered an exception. Even though the corporation has hired your client, it is likely just excited to provide these opportunities for its employees. Your client or you are the holder of the liquor license, not the corporation, so you are the party that needs to be aware of these regulations and comply with them. I want to go through a few other common scenarios that we see. Let's say a newly built sporting arena is seeking your services to operate its food and beverage concessions throughout the arena. When reviewing the proposed concessionaire agreement, you notice that there is a Fireball branded bar at the top floor of the arena that is used for consumers that purchase the highest level of sporting tickets. You find out that Fireball is the official drink of the sporting arena. If this kind of puts some hairs on the back of your neck, that is with good thought. Although this is likely going to be allowed, this is a highly sensitive and regulated topic in the industry right now. We've had a lot of sporting arenas change up their sponsorships. Federal and state law recognize the legitimacy of venue advertising. So long as other alcohol brands are offered at the Fireball bar, you as the concessionaire are not treating Fireball differently than any other products, whether that means of discount or otherwise, and the items being used at the bar are otherwise compliant with law, a situation like this can be permissible. If you do accept a sponsorship like this, avoid providing any extra promotion of Fireball, such as creating a Fireball signature drink, highlighting Fireball cocktails, or offering specials on only Fireball cocktails. All promotion of Fireball should come from the sporting arena only, as opposed to you as the concessionaire. I have one more scenario I want to walk through with you guys. Let's say you operate food and beverage concessions at a long-operating movie theater. A small local winery gives the owner of the movie theater $5,000 to renovate one of the restrooms. In exchange, the small local winery wants the movie theater owner to offer each brand of wine the small local winery offers. Is this going to be okay? Absolutely not. The agreement between the small winery and the movie theater impacts your operations because you are now being required to sell brands that you were not originally selling. The small local winery is using that $5,000 renovation fee as a mechanism of inducing the movie theater owner to require you to sell its brands. Let's change up the scenario a little bit. What if instead of the small local winery wanting you to sell all of its brands, the winery just asks the movie theater owner to put a little plaque above the bathroom that says, "In honor of small local winery"? Yes, this is absolutely going to be allowed. This arrangement has nothing to do with you or your client's operations, and it is not influencing you to purchase additional product, give the small local winery products deference over other products, or really impact your operations in any way. The movie theater owner is a standalone business, and as the owner of the standalone business, it can make improvements and accept sponsorships that do not impact you or your operations. There are 3 things I want everybody to take away from today. The first is to memorialize your agreements. Any sponsorship opportunity should be memorialized in a written agreement, and you should encourage your corporate clients to do the same. Federal and state law, as we discussed, often use broad terms like directly or indirectly, express or implied, with the intent of capturing any possible arrangement, whether written or not, or what actually happens. Having a memorialized agreement clarifies roles and gives you or your client the opportunity to include terms that could mitigate any liability or enforcement action. I recommend including language in your concessionaire or management agreements that clarifies that you, as the concessionaire and the liquor licensee, have complete and sole discretion in determining what alcohol brands you sell and what you will and will not accept sponsorship assets from an alcohol brand. 2 is to understand the applicable law. Any equipment, money, or other item of value furnished to you or to your client for your use or benefit should be carefully vetted to ensure that you are not accepting an item of impermissible value. If your client engages in a sponsorship arrangement, ask yourself, how is this impacting my operations? Am I being asked to do something that I wasn't originally being asked to do? Otherwise, how can I follow the money? And last, I always recommend to seek counsel. Reach out to your corporate counsel, or if you are a counsel, reach out to local counsel. Remember that sponsorship are extremely fact, location, and venue specific. Something that happens in California may not be allowed in Washington. Something that happens in a sporting arena may not be allowed at a restaurant. So it's very important to really remember that these intricacies exist and to seek counsel when necessary. That is all that I have for you guys. If anybody has any questions.
Thanks, Lauren. That was great info, so cogent. Thank you very much. And ladies and gentlemen, as she mentioned, if you have questions, you can pop them in the chat. Lauren, while we wait to see if anybody does pop a question there, first of all, I felt like I was back in law school with your scenarios. Thank you very much.
Of course.
It was probably a lot longer ago for me than others, but it still felt good. Second, can we walk away with a general rule? In the discrimination, civil rights area, we constantly remind ourselves that we're prohibited from doing indirectly what we can't do directly. That seems like a fair way to look at this as well, except that what you shared with us is the regulatory services go so far as to saying you can't do it indirectly. But is that kind of a fair way to kind of create a philosophy around this space?
Absolutely. Just because something is being given to your client and is then being given to you, even though the manufacturer wasn't giving it directly to the concessionaire, because it went through a third party or went through a slew of other people, that's not the way that the regulators are going to look at it. And they're going to look at it as if it was directly given to you, which is why that direct or indirect language exists to capture any of those scenarios.
And has your experience when there is an investigation that these folks are pretty good at what they do? So in other words, if we've got some folks that might be thinking, well, we won't put it in writing, as you mentioned, a little wink wink agreement, they're pretty good about following the money. And I'm guessing today that's relatively easy to do. Is that a fair description of what might go on there?
Absolutely. In the absence of an agreement, or even when an agreement does exist, TTB or state agencies have been really known to ask for email chains, Slack channels. They want to see everything. They'll see what's in the actual agreement, but if the actual agreement doesn't align with what they see, what was executed, best bet that they're going to ask for any kind of other communications, and they're going to go through every single page of those to make sure that there was no other understanding that would otherwise violate law.
Yeah, listen, I think that's a crucial point for everybody on this seminar to make sure their employees understand that. And my guess is, Lauren, that not if you do try to hide this or do it surreptitiously, and then you perhaps don't come clean when asked about it, there could also be some potential criminal exposure. Do you agree with that?
Absolutely, absolutely. There's criminal exposure, civil exposure, and it could be coming at you both ways too. The state level, federal level, any way that they will come at you, they will, which oftentimes they will throw the book at these violators. And then that's why we often see these offers in compromise, because there's so much that could come at these entities for engaging this kind of conduct. They finally say, you know what, we'll take the $5 million offer in compromise. We don't want to have to go down the criminal route
to mitigate the risk of what might come. Yeah, that's a very interesting thought there. Thank you for that. Last question from me is that I'm assuming in your practice there is that you spend quite a bit of time previewing potential promotions. I just want everybody to walk away knowing the scope of what you can offer. Is that?
Absolutely, absolutely. So a lot of what we do, sometimes we'll just have marketing agencies come to us and say, "Hey, I've gotten this food concessionaire as a client. This is something I want to start. This is a client that I have. What can I do in each state?" And we'll kind of give it to them on a broad spectrum. Or other concessionaires will say, "Hey, I operate a happy hour for this corporate client on Fridays. They just entered into the sponsorship arrangement. They've sent me the sponsorship agreement. Can you go ahead and take a look at it?" Or here's a menu that they want us to post during this happy hour. Can you take a look at it? Is this okay? So we really provide services anywhere from the onset, trying to help you understand proactively what is allowed. And also we really will review sponsorship arrangement and potential promotions on a case-by-case basis that says, hey, you can post this menu in California, but you can't post these umbrellas, or you can accept this money, but you can't accept this money. So we really will evaluate on a fact-by-fact basis.
Lauren, that's terrific to know. Thanks again. Terrific presentation, terrific content. Love the format. Please join us again soon.
Thank you.